Hello, again, I'm Joan Retman, Area Community Relations Director at the Gardens at Town Square. Before we start today's presentation on the power of planning, I would love to take just a minute to share with you a little bit about the sponsor of today's event, which is the Gardens at Town Square. The Gardens is conveniently located near downtown Bellevue and just steps away from local favorites like the French Bakery, shops at the Bravern, the Bellevue Public Library, just 1 block away. We're also just minutes from medical centers like Overlake and Kaiser. The Gardens at Town Square is really known for its feeling of independence and vibrancy, our relationship with the University of Washington, and our lifelong learning focus, its warm hospitality and lovely amenities, which includes one of the brightest and most cheerful dining venues around, plus a serene private garden courtyard. It's really our little oasis in the middle of the city. The Gardens features a wide variety of newly renovated apartments, which include studio, 1-bedroom, 2-bedroom, and even a 3-bedroom option. You can check out our website to see new self-guided virtual tours of some of these floor plan styles. Residential options at the Gardens at Town Square include independent living, assisted living, and memory care as well. Tours are currently available, including for that rare 3-bedroom option, which has just been renovated and ready for viewing in person. And now on to our presentation today, The Power of Planning. Our presenter is Katie Mars. Miss Mars was actually Katie Peterson not too long ago, so congratulations to Katie in just recently getting married. Katie was admitted to practice in the state of Washington in 2017. She earned her Juris Doctor from the University of Washington School of Law in 2017 and a Bachelor of Arts in English and Law, Societies and Justice from the University of Washington in 2014. Ms. Mars' practice focuses on elder law, Medicaid and VA long-term planning, guardianship, estate and trust planning, and estate and trust administration. Ms. Mars is a member of the Washington State Bar Association's Elder Law, Real Property, and Probate and Trust sections. Additionally, she is a member of the King County Bars Association Guardianship and Elder Law and Real Property, Probate, and Trust Law sections. She also volunteers for the Washington State chapter of the Alzheimer's Association. So Katie, we're so lucky to have you. Thank you for joining us, and we're looking forward to hearing what you'd like to share today.
Thank you so much for introducing me. I so appreciate it. And as always, it is wonderful to be able to present with you all. I do miss going to the Gardens. It's such a lovely facility, but also glad that we have the technology to be able to still connect even virtually. So like Joan said, I do welcome questions throughout the presentation. What you are now muted and your videos are off, which makes it so you can't really wave a hand to ask a question. So probably entering something into the chat bar is the best way to ask a question, or to temporarily turn your video back on so that I can see you and that you do have something that you would like to clarify. So how I'm gonna kind of go about this presentation today is we're primarily focusing on documents that you may get drafted for yourself that are gonna help you in planning for your life and then after your life, with some 3 really primary goals. 1, to make sure your wishes are carried out during your lifetime, after your lifetime, that you are avoiding conflict amongst family or friends as much as possible, if that's your goal. And then also to make sure that you have the financial resources available to be able to pay for your care. Now, I'm not a financial advisor, so I'm not going to tell you how to, expand your portfolio and all of that, but we may talk a little bit about what are other potential state or government benefits that could be available for you. And as you may or may not know, most benefits providing long-term care do have income or resource qualifications, which for most people, that means spending down their money before getting access to those benefits. So, talking about what are ways that you can maybe preserve the assets that you've worked for while also getting benefits so that you are as taken care of as you can be when you eventually need that care. The documents that I'd want to start with and that I personally think are, I think, the most important for people of any age over the age of 18 are your durable power of attorney documents. And you'll hear these kind of said in a number of different terms or phrases that all mean the same thing. General power of attorney, durable power of attorney, attorney in fact. Those are all used to describe a document that you are executing where you are choosing an agent to be able to make decisions for you if you are no longer able to. They're normally two different documents. Sometimes there is a hybrid, but it's generally one for medical decisions and one for financial decisions. So, to start off with the medical power of attorney, this document is really important for you to think about who in your life, whether it's family or friends, or whether it is a professional who you believe would be able to serve in this capacity and make decisions for your health care that are as close as possible to what you would want to decide for yourself. So it's somebody who's going to step into your shoes, take the job really seriously, and think about what is not only in your best interest, but the decisions that you would want to make made because our health is so personal to each and every one of us. And many people have very different ideas of how they want to be cared for or what medical treatment they want to have. So it's choosing an agent who's going to respect what your wishes are going to be. This medical power of attorney is not effective until you're disabled. So the power of attorney, your agent, as soon as you sign the document, you're waiving HIPAA. So they would be able to speak to your doctors or view your medical records and have an understanding of what your health and healthcare treatment is. But they would not be able to make decisions for you until you've come to the point where you cannot make decisions for yourself. And this can be fluctuating. You can have different moments in your life where you're unable to communicate or unable to make decisions, possibly temporarily. Let's say you get into a car accident or some other emergency where there might be a temporary period of time that you're unconscious or simply not fully able to comprehend what's going on. So that would be a situation where your agent would step in and be able to consent to surgery, talk to your doctors, determine where the most appropriate place for your care is going to be. Or it could be long term. So it could be as you age and possibly experience cognitive decline or some other illness or symptoms that causes you to be unable to make medical decisions or communicate those decisions. So you're choosing a person that, in the case that you can't make those decisions for yourself, that you believe is going to do the best job in making those decisions for you. What is typically connected with the medical power of attorney is a healthcare directive. This can also be called a living will. It's really the same thing, but it is a document where you are expressing your wishes for healthcare when you are unable to communicate or make those decisions for yourself. Typically, it's in a very narrow set of circumstances when you are either terminally ill and the doctors have determined that you have less than 6 months to live and you're also unable to express your wishes, or you are permanently unconscious. And the health directive, it varies from form to form what you might be expressing, but some typical things that you'll see are whether you want artificial hydration or nutrition, so through IVs, whether you want to be resuscitated, whether you want to have artificial ventilation or a breathing tube, and whether you want to have pain medication administered. So there's a number of different things that you can determine if I'm in this circumstance in the future, what kind of care do I want provided, or what kind of care do I want withheld so that I can maybe pass more quickly or naturally. Your power of attorney for medical decisions, this is where this is especially important, is they have the ultimate discretion in those situations. So even though you may provide what your wishes are in your directive, because the medical field will change, because your situation might be more complex than what the directive could understand about what your future holds, your agent themselves, they will have the ultimate discretion to determine what is the best choice for you based off all of the information in those circumstances. So it's really a good guideline for them, but they are ultimately the ones who would make that decision. Now I'm going to pause here for a moment before I move on to the durable power of attorney for finances to see if anybody has a question about the medical power of attorney or the healthcare directive. So you can turn your video on or you can enter something in the chat bar.
Katie, I see a question from Gary. Gary, I'm sorry, your computer's on mute, if you don't mind.
Okay, how's that? It says
You're good,
mute.
Gary.
Okay, quick question. I have a directive, what do you call it, healthcare directive, but is it also true that they have one about something with regard to Alzheimer's or something or other? Is it different? There's a different type of one other, I mean, in addition to just straight healthcare directive?
Yes, so healthcare directive is kind of an umbrella term for a document that you are expressing your wishes for future care. Different forms may include Alzheimer's or situations where you don't have, where you've lost cognitive functioning. Other healthcare directives are, like I said, that's only if you're terminally ill or permanently unconscious. So there are ones like you're talking about that do specifically deal with Alzheimer's or even more broadly expanded to mental health.
So you would need a two, or would be combined into one healthcare directive? Or would you need
can find them combined into one. Or you can, if you already have one and you like it, but you would like there to be additional instructions and you find a form with Alzheimer's questions, you can also execute that and keep both of them.
Okay, because I don't have anything regarding Alzheimer's. I mean, it's strictly, in medical, whatever, like in unconscious or, do not resuscitate and all that. But the mental aspect of it is, I don't have anything like that. So that's something I should look into then.
Yeah, that's something that you can look into. And also there are, I think the Alzheimer's Association has lots of resources on that. It's also something to think about, really having conversations with your power of attorney for healthcare, because this document is really just serving as a written guideline to them. You can also express those same wishes directly to them. So you can be looking up questions online about treatment for Alzheimer's or other conditions, and be really engaging in a conversation with your agent so they know where you're coming from about the type of care that you'd like to receive.
Okay, thank you.
But one form is adequate, right? The standard form that will take care of Alzheimer's. You are disabled. You can't make your own decisions.
Yes,
and
absolutely.
somebody has to decide that.
Yes. So that's adequate. And it's a very personal decision whether you want to put down in writing what you would want if you have Alzheimer's, or to expand the scope beyond simply being permanently unconscious or terminally ill. Some people want that to be included and some people don't, because it's a very personal thing. And a lot of people, I think that their views on it changes whether they've had close relationships with people with Alzheimer's or cognitive decline or not. So it's very, very much a personally motivated decision. Are there any other questions?
So you say find these forms, are you finding them online? Is that where I should be looking for that form, the directive?
So for forms, you can find just about everything online. You can also have an attorney draft them. And I think the biggest difference is how much you want something to be customized to you, and how much with an attorney, what you're really paying for is the consultation to explain to them what your situation is, and to have them explain what are your risks or what is the most optimal choice and what's going to be the best fit for you for documents. For the healthcare directive, that's something that I think a lot of people actually do find online. You can, of course, find with an attorney, but there's also resources like I think 5 Wishes or End of Life Washington or Seattle University that all have quite a bit of information as well as forms regarding healthcare directives.
The hospitals and your doctor's office could have them too.
Yep, absolutely.
What was the other term you used for the healthcare directive?
It's also called a living will.
Okay, thank you.
And nobody's asked this yet, but I think I'll slide in there. It's important to note that the healthcare directive and the living will, those are both the same document, but they are different from a POLST, POLST, which is the physician's order on life-sustaining treatment. And that is typically a lime green piece of paper that you get from your doctor. And for many people, once they've signed that, they keep it somewhere very visible in their home, like their refrigerator. And that is what is respected by EMTs if they come to your home. And the POLST you can sign in the positive or the negative, but for many people, when they sign the POLST, what they're wanting to express is, if I have a heart attack, I don't want CPR or I don't want any treatment. So if emergency professionals come to my home, I do not want them to interfere or provide life-sustaining treatment. Your healthcare directive or your living will, that is once you've already made it to the hospital. And then it's a decision of whether to carry on with the machines or to pull the plug, as you will. John, you have a question?
Yes. Well, I have a comment, really. Perhaps you know Honoring Choices Pacific Northwest. This is a joint effort of the Washington State Medical Association, Washington State Hospital Association, and I'm on their advisory council. And they have formed this organization, Honoring Choices Pacific Northwest, and they have a multitude of information online. And the POLST just was revised this year, and it's changed one word. It's now called Portable Orders for Life-Sustaining Treatment. They took off, they changed it from physicians to portable. But and I don't have
take me months to remember.
Thank you. Thank you.
Thank you, John. That's an excellent resource.
Katie, we have a question that came up through chat that I'll ask you quickly. The question is, does somebody need to be declared incompetent or incapacitated by a doctor for the named durable power of attorney to be able to make health and/or financial decisions?
That's a great question. And there's a couple different answers to that. So the medical power of attorney, well, at the start, it all depends on how the power of attorney is drafted. So there will be some medical power of attorneys that will say this is not effective until there is a written statement by a doctor that you're incapacitated. What I prefer actually in my drafting is to have it be much more fluid. So if in the moment that a medical decision needs to be made, that your doctor determines that you are unable to make that decision or communicate that decision, then your power of attorney for healthcare can make that decision. But then that's not a permanent change. And then forever on, you can't make your own medical decisions and your power of attorney does for you. It will fluctuate back and forth. So it's effective in any given moment that you don't have the ability to make medical decisions. But then in any given moment that you do have the ability, then your doctor should be asking for your decisions and your consent, not the power of attorney for healthcare. The power of attorney for finances, and that's a good, we can kind of, let's segue over to finances. If you have a question about the medical, we can hit that again later. But the power of attorney for finances, similar to the power of attorney for medical decisions, again, you're appointing an agent that you trust who's going to be able to step into your shoes and make decisions if you're not able to. You have two decisions with this document as far as how it becomes effective. One is you can have the document be effective immediately, meaning that there's no additional action that needs to happen in order to give your power of attorney the authority to act under the document once you've signed it. The second is only effective upon disability. And effective upon disability, what the power of attorney typically requires is a letter from your doctor stating that you are incapacitated to the point that you cannot make financial decisions or manage your finances on your own. So there are differences between folks, which one they prefer. I would say effective upon disability. Most people, when they hear that, they first align with that and think, well, I don't need somebody managing my finances until I truly can't manage them myself. But then when you talk about more of the practicalities of how that works, I think a lot of people then switch back and think, well, effective immediately makes more sense. When it requires a doctor's letter, and if you think of all the different times in your life when, what happens, what scenario is occurring that you need your power of attorney to act, getting the letter from the doctor can be quite inconvenient and can potentially be an obstacle that you don't want your power of attorney to have to go through. So let's say you have an emergency and go to the hospital, and potentially the doctor at the hospital doesn't want to sign that letter because they're not really sure of how permanent or not your situation is. Maybe the primary physician doesn't want to sign it because they said, well, they went to the hospital, I haven't seen them. So it can be a little challenging to get the letter. And then the letter gives the impression that forevermore you won't be able to make your own decisions. And that may or may not be the case. You could have a full recovery and go back to managing your finances. And then you would need for that letter to be revoked so that you could continue doing so. And your power of attorney no longer has that active role. If it's effective immediately, for a lot of people, it's a bit of a smoother transition. Lots of folks, it's not just black and white. You have full capacity, you have no capacity. It's a bit of a gradual slide where maybe you want more assistance. Maybe you want your power of attorney to be on your accounts and to be able to just kind of check in and make sure everything's running smoothly. Maybe you want them to file your taxes, but you still want to manage your checkbook. Maybe you want assistance with certain things, but you don't want to completely hand over the reins. Also for couples, for a married couple, there can be a lot of reasons why you want to use the power of attorney, maybe before there's any issue of capacity. Like if you're selling real property, you can use the power of attorney to sign for your spouse if they can't be there. Or if one of you has been assigned the fun job of doing taxes for both of you, or having to deal with Social Security, or any number of things, it can be for convenience to use the power of attorney, not necessarily incapacity. And then once you get to a point of potentially being incapacitated, there's no additional step that you have to take in order for your power of attorney to step in. And for most people, what kind of the biggest question I ask them when they're deciding which one they want is, if you are leaning towards effective only upon disability, is there any part of your brain that's thinking, well, I don't want them to come and take my money before I'm incapacitated and get control of all my stuff right now? And if that's the case, I'll tell you that most people don't get more trustworthy once you are incapacitated. So it's really important to think of, is this somebody who's going to respect my wishes? And if I tell them it's effective immediately, but I don't need you to do anything yet, will they respect that or not? Because that will tell you a lot about your agent and whether they're really a good fit for you, because this is a big responsibility, managing your assets and making sure that they're used appropriately for you. That was a long-winded way to answer that question, but let me know if you have a follow-up or if there's something I missed on it. Some other things to consider with the power of attorney for finances are the different individual powers that you're giving to your agent. So there are standard powers that every power of attorney is going to have, and that is you're giving them basically an extra set of keys to the car. You're letting them have access to your bank accounts, to your retirement accounts. They can talk to Social Security on your behalf. They can make sure your taxes get filed, make sure that your bills get paid. If they're on your bank accounts, they can write checks on your behalf. They can hire professionals in order to help them carry out their duties because they have a fiduciary duty towards you. They have to act in your financial best interests. So they could hire a CPA to assist them, or they could hire an attorney to assist them in making sure that they're doing taking the right steps as your agent. Some additional powers that are not included in the power of attorney, unless you specifically include them, are things like gifting. So do you want your agent to be able to gift away your funds? And a lot of this depends on what your goals are. Let's say that you have a monthly tithing to your congregation that you've done for a long time. And even if you become incapacitated, if you still have the funds to do so, maybe you want your agent to be able to continue that tithing. Maybe you have an estate that could potentially have estate taxes when you've passed away. And so part of your tax planning is to be able to make gifts during your lifetime to reduce your taxable estate. So maybe you want your power of attorney to have the discretion to make those gifts in order to avoid taxes when you pass away. So there could be reasons that you may want your agent to gift, or you might feel uncomfortable with the idea and think there really isn't a good reason for your power of attorney to be able to gift away your assets. You may want them to be able to sever community property or joint tenancy. And oftentimes the reason for that is Medicaid planning, which for spouses, you might want to separate up their property to avoid future estate recovery and to assist with one spouse going on Medicaid. Or transfers between the spouses. You may want to be able to transfer real property in between, again, for potential Medicaid purposes. And that's where the difference between an online form and an attorney. Online form may be able to give you check boxes that you can say, I want this power, this power, this power. And if you understand the consequences of those powers, that can be something you can do. If you work with an attorney, you're going to be able to talk about how will these powers specifically impact me or my family? What are the potential consequences or risks or conflict that could arise from these powers? And you can talk about what's going to be the best fit for you. All right. Does anybody have questions about the power of attorney for finances?
Yeah, Katie. I'm the youngest of three in my family, and I have no one else, other than my relatives that, like no ex-spouses, no whatever, children, nobody. I have my the order of becoming power attorney. In my case, I have my oldest brother, number one, my older brother, number two is my oldest. Then I have my oldest brother's nephew, who's mid-40s. I mean, perish this thought, but I just occurred to me today. What happens if it turns out that all three, I mean, kind of pretty unusual, that all three of those people would predecease me. And all of a sudden, a month later, I happen to go. Does the first person's, I mean, I got nieces and other nieces, whatever, or do you have to specifically name, in case, all three of these people are gone and I'm still here and then something happens to me, who would become my administrator or executor of the estate, or, do you have to name a fifth person?
Yeah,
person?
so I'll answer that in a couple parts.
Okay,
So first is, so your administrator or executor of your estate is
yeah, and
separate from your
all
power of
three of these, yeah, all three of these people are also for the health and everything. In other words, I got.
Yeah,
Yep,
yeah, and for many people, they use the same people for these different documents because those are your trusted folks.
correct.
So Gary brings up a good point in that the power of attorney that might be the best fit for you if something happened to you tomorrow might not actually be available to serve as your power of attorney when you need them. Particularly if it is somebody your age or older, they might need assistance at the time that you need assistance. So having them and then backups, and like Gary has, having options that are maybe significantly younger is really good planning for your powers of attorney. Now, Gary, if all three, hopefully not,
Right. Yep.
If all three, if something happened to all of them and they could not be available, if you still had capacity, if you had the ability to execute a new power of attorney, of course you could do that. So if you were able to say, I want somebody else to manage my finances, and this is who I want to do it, and this is why, then you can execute a new power of attorney. If you're at a stage where you're not able to execute a new power of attorney, that's where guardianship comes into play. So then somebody has to petition for guardianship if you no longer have the ability to execute a power of attorney. And guardianship, it's basically a fail-safe. It's a last resort option for making sure that there is somebody appointed to make the decisions that need to be made for an individual. The power of attorney's goal is to avoid a guardianship. So a document that is relatively easy and inexpensive to execute, which you get to choose the person making decisions, and that person does not have decision-making power that overrides your own decision-making power. That is what we hope for. But if you don't have a power of attorney, or if it's not working because none of the folks in your power of attorney can serve, then somebody petitions the court to have a guardian appointed, and they would be able to make those decisions. But it is a legal process, essentially, where your rights to make those decisions are stripped away because the court determines you don't have the capacity to do so. So it's really good to be very intentional thinking about your power of attorney and give it the best odds that somebody is going to be able to serve. And for lots of folks, especially if they have agents that are maybe the same age as them or older, they do put somebody younger, or they consider putting a professional as a backup. So there are professional fiduciaries who will serve in this role, and they might be good to have in your power of attorney in case your other agents are unavailable. And that's kind of your last step. And of course, they get paid. So for lots of people, they would prefer somebody they know and somebody who maybe isn't going to ask for payment over a company that will get paid. But it's at least less expensive and less restrictive than a guardianship.
Okay, thank you. Thank you.
Yeah. Any other questions? Okay, then we can go ahead and move on. So those are the power of attorney for finances and healthcare directive. And those are really the documents that are allowing you to direct what happens to you, your care, where you live, how your assets are managed at a point in your life where you're maybe unable to make those decisions for yourself. So that's the best way that you can control what's going to happen during your life, how you're going to be provided for at a time where you're no longer directing all of this. Now we kind of switch over and transition into planning for your wishes after you have passed away. And the first document that I always start with, and for most people, it is kind of the basic foundation of their estate plan, is a will. So a will is a document that determines where you want your assets to go So to what beneficiaries, whether they are folks that you know or charities, how it's going to be divided up amongst them, how it's going to be potentially held for them, whether you're going to give it to them directly or potentially held into trust. And then who are the people that you trust to make sure that your plan is actually carried out. So a will, typically the things you want to think about are, if you were to pass away tomorrow, what are the assets that you have? What are the assets that you are planning to have or potentially will have in the future? And what makes sense on how to distribute them and who you want to receive them. And this is where thinking about who your family is, or your friends, or what charities that are important to you, for you to be kind of thinking this through. And for a lot of people, before you ever talk to an attorney, it's a good idea to think in, and have conversations, possibly with your spouse or with your loved ones, about how you ideally would want things to look like and what is really important to you for how things get carried out. Whether it's important for you to try to avoid probate, or important for you for things to be fair, or important for you to try to avoid conflict. Thinking about what your goals are so that when you talk to an attorney, you can make sure that they really understand what your situation is so that you're getting the best advice for what you're looking for. For beneficiaries, you want to think about if your beneficiary has passed away before you, where do you want it to go after them? If they are a minor, anyone under 18 cannot receive an inheritance directly. So it either goes into a custodial account to be released to them when they're 18, or it can go into a trust for them. And a trust allows you to have a little bit more control. So you can determine at what age you want things to be released. You can determine what the money should be used for. And you can have a little bit more guidance as far as how your inheritance impacts the life of your beneficiary. A trust can be especially useful if you have any beneficiaries who are disabled or who require care or are going to be on benefits. So if you have a supplemental needs trust in your will, then you can potentially provide for somebody who is disabled and be able to provide maybe a better quality of life, but still allow them to maintain any government benefits that they are receiving or might receive in the future. So you can give them kind of the best of both worlds. So it's good to think about who are the beneficiaries and how is this inheritance going to impact them, and what's the best vehicle for getting that money or those assets to them. When you're considering your will, of course, choosing your executors is a really important step. And so you want, very similar to the power of attorney for finances, someone who is responsible, someone you trust to carry out your wishes and not to put their own agenda ahead of things, but who's actually going to make sure that your plan is carried out exactly the way you want it to be. And also, like the power of attorney for finances, you want to have backups, and you want to think about, you might pass away sooner, or you might pass away decades from now, and who is likely to be available and able to serve at that time. So maybe having someone your own age, maybe having somebody younger than you, and then you can, of course, always appoint a professional again, if you want to make sure that you have that extra security. For your will, another really important consideration is actually thinking about the character and what type of assets you actually have, as to whether they are going to pass through your will or they're going to be considered non-probate assets. So probate and non-probate just means whether it's an asset that would typically flow under a will and through the probate process, which probate is the process by which the court oversees how your assets are transferred, or are they non-probate, meaning that the assets are typically going to be directly transferred via some sort of contract. And what that typically looks like is like life insurance, where you have a beneficiary designation. So you have a contract with the life insurance company that says the assets are skipping probate and going straight to your beneficiary. You might also have that for IRAs or different types of accounts, or if you have real property that's joint owners with right of survivorship. The right of survivorship part of that deed is a contract that the home immediately vests in the other owner and doesn't have to pass through probate. But understanding what is going to be probate and non-probate will help you to understand what is actually going to flow through the plan you've created in your will and what is going according to a contract. And it's important to contact your financial institutions that are holding your funds and figuring out whether you have a beneficiary or payable on death or anything else that's set up so it's going to be non-probate and will pass immediately to someone, and making sure that's actually aligned with your plan. I've definitely done wills for people and they had no idea that they had beneficiary designations on their accounts. And those beneficiary designations were completely different from what they had in their will and what they wanted their plan to be. And those can be different, your beneficiaries in the will, and some people choose to do that on purpose. So they know what assets are going into the will and they want it to go to these people. And then their assets that are in accounts that have beneficiaries, maybe they have done that on purpose, that they want them to go to these other people. But it's really important to understand what assets you have in particular to make sure that they're actually going to go according to your plan. Okay, before I kind of continue and expand on estate planning and what you can do, does anybody have any questions here? Okay. I must have been just abundantly clear. It's crystal clear.
May I ask what the amount is before it goes to probate?
That's a great question, Linda. So in Washington, if you have cash assets, so in a bank or investments, etc., that are under $100,000, then there is no probate. You can do a small estate affidavit. Now, if you have $90,000 in cash and you own a house, you're probably going to have a probate. Real property is usually a probate asset. Real property is not a probate asset if it is in a trust or if it is joint ownership with right of survivorship, or if it is community property with a spouse and you're able to do an affidavit, you have a community property agreement. So with that, we can kind of segue a little bit into how you can just avoid probate altogether. So probate, again, it's the process through the courts. If you're from California or some other states, you might know that probate can be truly terrible. In Washington, it's actually pretty simple. So for a lot of people in Washington, they don't necessarily want to avoid probate because it's really not that bad. It can be just a few $1,000s in total, which is pretty similar to if you had a trust and trust administration of the property. And so people might not want to avoid it, but for those that do, the ways to avoid probate are either to have a trust, and you can have a revocable living trust, which is a trust that you create during your lifetime, and then you transfer your assets into this trust. So if you're kind of a visual person, you can think of the trust as a bag that you're shoving all of your assets into. and then this bag carries you straight past probate and then gets dumped out by the trustee to where it's supposed to go. For a trust, though, to work, you need to actually transfer all of your assets into it. So for bank accounts and investment accounts, they have to be changed into the name of the trust. Real property has to be deeded into the trust. So it's something that you do have to keep track of, because there's lots of folks that might have done a trust many, many years ago, transferred assets then, and then acquired new assets and forgot to transfer them into the trust. But if you're able to keep track of what you're doing, that trust can allow you to completely avoid probate and not have to deal with the courts at all when you pass away. And simply what you put into the trust document, that is what the trustee is going to follow as far as making sure your assets go where you want them to go. Another way is to make sure all your assets are non-probate. So if most of your, let's say that you've sold your house, and so now all of your assets are retirement accounts and life insurance policies and bank accounts, investments. If you go through and just make sure that all of those accounts have up-to-date beneficiaries, then all of those accounts will transfer according to those beneficiary contracts, and you won't have a probate and you won't have to deal with that. So it can be a really simple transition, especially for people who don't have real property, in order to avoid probate. Any questions about that? Okay. So it looks like, is it 10 minutes left?
Yes.
Okay. So for the next 10 minutes, what I can kind of talk about a little bit more is more of planning for passing, and talk more about making sure that you have contacts and passwords, and can expand more as far as trusts or any other end of life planning. Or I can talk more about potential benefits planning and financial resources available through the state. And I can let one person, if anybody wants to give a shout out of which they would prefer for us to spend our last 10 minutes on, I'm happy to take that. Or it'll be dealer's choice and I'll make up my mind.
I have one question. Can you hear me?
I can hear you.
Yeah. My question has to do with transfer on death deed, which I think is fairly new in Washington State, whereby upon one's death, the property transfers immediately to whomever is the transferee. Is that correct? Yeah.
Yeah, so a transfer on death deed is essentially, it is a quitclaim deed that you execute before you pass. And then when you do pass, that deed and an affidavit is then presented to the county recorder's office, and the house is automatically transferred. And so this is another way that you can avoid probate if you have real property. And I think that it is a good tool when you specifically have one person that you want the house to go to, and you are very confident that they are still going to be alive when you pass away. If you have more than one person, it's not a very efficient transfer, because oftentimes people don't want to be co-owners. Maybe if they're spouses, or if you know that they really want to own it together, you could do that. But most people don't want to be joint owners of a house that they've inherited. For many people, they end up selling the home and then splitting the proceeds, which is easier done through a trust or probate. But if you have one person who you know actually wants to live in the house or keep the house, then the deed can be a good tool. If that person has passed away before you, then you've paid to execute this deed and it doesn't work out and you're going to have a probate anyway. So that's where it's just not super cost efficient if the odds are the person isn't going to survive you. Does that make sense?
It makes sense, but can you have a secondary beneficiary if that person does not survive?
Typically not. So the deed is normally you're naming one round of beneficiary. It's not, the deed itself can't say to this person, but if they haven't survived me to this person. You could possibly, and this is something I have never looked into, but maybe you could execute 2 deeds. And then it just depends on which one survives. But then you're starting to get into potentially more complicated than the goal. You know, if the goal was for it to just be very simple, then you're starting to complicating things a little more than maybe what you're originally intending.
Mhm. Thank you.
And Katie, I have a question that popped up in chat,
Mhm.
and then I have feedback for the request of how to cover the remaining time. So 2 things. So the first is the question, which is, can someone put money from the sale of a house, for example, into a trust to pay for care and have any balance of the trust to be paid out to named surviving beneficiaries, such as when a parent passes? In other words, trying to find a way to manage money from home sale to pay for care. That's the question. And then the feedback would be interested in hearing about services for any time remaining.
Okay. Well, those both go kind of towards services. And I'm going to go way faster than is actually going to give you a complete view, but it gives you a little taste. So for most Medicaid planning, I will say, is for spouses. So the state has realized that it is unfair to impoverish both spouses for the sake of providing care for the first spouse who needs it. And then they've realized that they also end up at the end of the day paying more by both of them eventually having to go on Medicaid. So what used to be the big Medicaid planning solution was a Medicaid divorce, which thankfully the state realizes also a pretty unfair thing to do to people in order to pay for care. So there are ways that you can have exempt assets, such as your primary residence is typically exempt. When you sell the house, those proceeds are typically countable. So for a lot of people, keeping the house until after applying for Medicaid and then selling it is a really good strategy for couples, because you can transfer the house to one spouse. One spouse can go on Medicaid, and then the other spouse can sell it and use the proceeds in any way that they want. There are also annuities available and other options for spouses to be able to keep resources for the spouse that's not going on Medicaid. For single folks who are not married and don't have those planning options, there are a lot less options. And typically, I have a lot of people who think, well, can I take my money and put it into a trust, and then that can be used to pay for my care? That's a really common question. There are very narrow circumstances where you can actually do that. For instance, if you are under the age of 65, you can fund a self-settled special needs trust. So you can create a trust that is for yourself, that can be used for your care, but is not a countable asset for purposes of Medicaid. So you could be getting benefits, and then the money in the trust could also be supplementing. If you're over 65, that trust is not available to you. The only trust that would be available to you are either a pooled trust, which you are combining it with monies from lots of different folks. It's managed by an organization, and there are penalties, transfer penalties for purposes of Medicaid. So typically you do that, and then you have to wait 5 years, but the money in the trust can pay for your care during those 5 years before Medicaid kicks in. The other trust available is to do an irrevocable living trust. And this is where it gets really dicey, because you're actually giving your money away. It's irrevocable, and there has to be a beneficiary other than yourself or your spouse. So you are giving your money to somebody else, and then you have to wait 5 years before applying for Medicaid. And then if the person you've gifted the money to is very trustworthy, they could use the money to assist you. But of course, the big risk is that you no longer have any legal authority over that money. You have given it away. And if they choose not to use it to help you, then you're out of luck and you end up having to sue them. So that is oftentimes not the best strategy for a lot of folks, but there are some different planning strategies, which I think reaching out to elder law attorneys, especially elder law attorneys who specifically state that they do Medicaid or VA planning, is a good way to present what your assets are and what options could be available. 3 o'clock. Okay, that was my 5-minute spiel about benefits really quickly.
Thanks, Katie. Do we have any one final question to ask Katie before we wrap up today?
If I have the transfer of death deed, do I maintain control of it until I die, so that if I give it to my son, I still have control and can sell a house or something
Yes.
before? Okay.
Absolutely. The transfer on death deed, it only gives them any authority, any vesting ownership when you have actually passed away.
Okay.
And you could revoke the deed at any time. You could sell the house, do whatever you want.
Okay. Thank you.
Okay. Thank you. Thank you so much, Katie. Fabulous job. That was amazing. I learned a lot of information today. I think everyone else did too. Thanks so much for your time. Again, if you have other questions that we didn't get to today, we'll do some follow-up calls to you so that you have a chance to share those questions with us, and we'll get them to Katie to respond to as well. The next thing that will happen after this call is you'll receive an email from us with just a very short evaluation form with just a couple of quick questions on it that we would love for you to take a moment to complete for us, to give us feedback on today's topic, but also suggestions for future topics as we continue to do Zoom calls like this to get important information to you. And then lastly, we would love to hear from you too, if you take a moment to look at the screen for the next upcoming event, which is in collaboration with the University of Washington's Memory and Brain Wellness Center, a wonderful organization, and we're going to be doing a talk on how aging affects brain function and thinking. So that's coming up on Wednesday, May 19th at 2 p.m. So you can please let us know if you're interested in that as well. So thanks so much again for attending today, and we look forward to seeing you again soon. Have a wonderful day, everybody.